case briefs, and so much more. LSData's got what you're looking for.
In 1983, the United States Supreme Court scrutinized Indiana's tax sale process in the landmark case of Mennonite Board of Missions, MBM, versus Adams. Central to the proceedings was the constitutionality of Indiana's tax sale process, specifically relating to what constitutes adequate notice for those potentially impacted by such sales. The legal dispute grew out of a tax sale involving a property in Elkhart, Indiana, on which Alfred Gene Moore had executed a mortgage with Mennonite Board of Missions. Unfortunately, Moore failed to pay the property taxes unbeknownst to MBM. The state's law granted the county treasurer the power to host a public auction of the property to the highest bidder, the high bidder winning not the property but a lien on it, feasible for redemption by the original owner or lion holder within a 2-year window. The primary debate revolved around the state's process of notifying interested parties. Prior to 1980, Indiana law made no provision for notice to mortgages and relied solely on public posting and publication methods for alerting potential bidders and affected parties to a tax sale. The nub of the issue being, was this manner of notification enough to safeguard the interest of parties like MBM, whose property rights might suffer due to these proceedings? MBM thought not, and so upon not receiving proper personal notice, they appealed, arguing that this violated their rights under the 14th Amendment's Due Process Clause. The Supreme Court agreed. According to the majority judgment penned by Justice Marshall, the published notice alone was not enough. The court ruled that affording due process means informing the interested party about an action that could impact their property rights with a method promising actual notice, such as letter or in person. This led to a drastic decision. The tax sale was deemed unconstitutional. The court held that minimal constitutional requirement for such proceedings must guarantee actual notice to a party whose name and address are reasonably ascertainable. Consequently, the case got sent back to the Indiana Court of Appeals for a more constitutionally attuned hearing, marking a significant change in how such matters are approached.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind, leave the stress of class.